Thank you, sir. Good morning, everyone. I am Harsh Anmol, the student coordinator of Center for Legal Aid Program, NUSRL Ranchi. On behalf of Center for Legal Aid and Pro Bono India, I welcome you all to the last session of short-term course on legal aid and allied laws. Today, for a session on Right to Information Act, we are privileged to have with us Mr. Shailesh Gandhi. Sir is a first generation entrepreneur and a distinguished alumnus awardee of IIT Bombay. Sir was a part of the national RTI movement, which was involved in drafting the National Act. He has also been the convener of the national campaign for people's right to information. Sir has used RTI and has also trained many citizens and government officials in over 1,000 workshops to use it. He was the only RTI activist to have been chosen as the Central Information Commissioner and has a record of disposing over 20,000 cases in 3 years and 9 months, which has ensured that most cases were decided in less than a period of 90 days. Sir gave many landmark decisions on RTI, apart from organizing the first digital paperless office in the Commission. Sir is passionately pursuing the cause of evolving ways for a time-bound justice delivery system and improving governance systems. Amongst many awards, he has been awarded with the Nani Palkhiwala Civil Liberties Award and the MRPI Award. Sir has also published a book titled RTI Act, Authentic Interpretation of the Statute, and a paper critiquing Supreme Court judgments on the RTI. We welcome you, sir. Please begin with the
Thank you
session.
very much. Okay, will someone start the presentation, please, from your end? Hello.
Sure, sir.
Yes, sir. Harsh is uploading, sir.
Yes, sure. Fellow citizens of India, thank you very much for attending this, and I am thankful to Dr. Gupta for giving me this opportunity of talking to all of you. Keep this slide until I ask you to move ahead.
Yes, sir. Thank you.
We say India is the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. लोकशाही का मतलब होता है लोगों का शासन, लोगों के जरिए शासन और लोगों का रूल. Question I would like to ask you to think about in your minds. अगर आप सरकारी दफ्तर में जाते हैं, आपको इस देश का शासन करता है जैसे कोई ट्रीट करता है क्या? Doesn't even treat you as the ruler of this nation. The obvious answer is no. Then how are we a democracy? Are we a sham democracy? If we are a democracy, we should be the rulers of the nation. Or is the definition of democracy different? The reason why India is called the world's largest democracy is because we have a reasonably fair system of elections by which we are able to change governments, leaders, our representatives. And these representatives in turn run the government, appoint bureaucrats, and so on. I'll submit to you that, to my mind, having a fair system of elections and a constitution are necessary conditions for a democracy, but not the complete set of conditions. The heart and essence of democracy is the concept that each individual citizen is a sovereign in her own right, and she gives part of her sovereignty to the state, in return for which she gets the rule of law. Sovereignty of the individual citizen is the heart of democracy. Without that, democracy does not exist, cannot exist. It's a sham. Once, when giving a physical talk to a group of students, I talked about this, and one young student got up and he was very frank and free and said, Mr. Gandhi, ये बातें तो बड़ी अच्छी चटनी चुपड़ी लगती हैं. 140 करोड़ बादशाह और बेगम से देश चल सकता है. Can a state run with 140 crore rulers? Was a question he posed. What I mean by ruler of the country and what I mean by democracy, let me illustrate with two simple stories. The first is about the United States of America. I'm not saying everything in the USA is right, but in terms of democracy, they have a 2-century lead over us. An immigrant from India, Pakistan, Bangladesh, China, if he has applied for the citizenship of the United States or green card, which gives him permission to work in the United States, he will easily pick up the telephone and ask about the status of his application, whether it's accepted, whether there are defects, when is it likely to be considered, and so on and so forth. And 99%, you'll get a perfectly rational answer from the other side of the telephone because a human being has called. Therefore, the system responds to him. The second example I'd like to give you is a story you've all heard. This story is 125 years old. Mohandas Karamchand Gandhi got inside the train in South Africa. He had a first-class ticket, but the white man objected, hence he was taken off the train. In the same story is written that Mohandas Karamchand Gandhi filed a complaint by telegram complaining about what had happened to him. And in 12 to 14 hours, a railway official came and put him on the next train. Think of this. Mohandas Karamchand Gandhi was not a citizen of South Africa. By South African law, then he was a second-rate human being. Even as a human being, he was not considered a first-rate human being because he was not a white man. Despite that, despite such a law in existence, because one human being complained, the system responded. Think about it, my friends. Today, if you file a complaint with the railways, we have got mobile phones, we've got internet, we've got so much speed everywhere. In 12 to 14 hours, forget 12 to 14 hours, in 12 to 14 days, if you get a response acknowledging your complaint, you will say, "Arey, railway ne jawab to diya." That is what I mean by true democracy. That is what I mean by respect for the individual. That is what I mean by the rulers of the nation. Now, we say we are a democracy. We conceptually accept that we are a democracy, but in actual practice, it does not come about. RTI, for the first time, actualizes this position of making democracy work, of giving you some concrete proof that democracy works. The concept is that if the government belongs to citizens, if citizens are the rulers of the nation, everything that is government belongs to them. You, my friends, are the badshahs and begums of this nation. And I'm hoping at the end of this talk, RTI का तो हम लोग बात कर लेंगे और आप समझ लेंगे hopefully. But more important than that, I'm hoping when you get up from this session, you will get up believing that you're the badshahs and begums of this nation. If that happens, I'll have served the purpose, and the right to information will have served its instrumentality of making you the center of this nation. The first such law came about 250 years back on 2nd December 1776 in Sweden. It was introduced by a Finnish clergyman, Anders Shailesh. After that, for 150 years, no country had such a law. In the last century, we have now got over 130 countries having such a law, which guarantees transparency of government working. And these laws go by 3 different names: access to information, ATI; freedom of information, FOI; right to information, RTI. India came up with a proper national law codifying our right. Mind you, right to information was not given to us by this law in 2005. Right to information existed the day the Constitution of India was made and the day Article 19(1)(a) came into operation, which was on 26 January 1950. But in 2005, this got codified. We said, yes, you have a right over all the government information, but how do you actualize it? There was no way. This codifies it elegantly and is one of the best transparency laws in the world, in my opinion. Implementation we have not done as well as we should have. We'll come to that later. Next slide, please. The preamble of a law determines the objective and what it is expected to achieve. Let's read this preamble together. Whereas the Constitution of India has established democratic republic, and whereas democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed. And whereas revelation of information is actual practice, is likely to conflict with other public interests, including efficient operations of the government's optimum use of limited fiscal resources and the preservation of confidentiality of sensitive information. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal, the RTI Act beautifully harmonizes these needs. Some people talk of difficulty in running government and so on and so forth. 18 साल हो गए ये कानून implement करते हुए. And there is not a single instance anybody is able to find out about any major damage to any interest of the nation. This has worked very well and should actually be made to implement in a proper fashion. The argument that right to information आएगा तो सरकार को क्या हो जाएगा, सरकार कैसे चलेगी, we've long past proved that nothing serious goes wrong with the government. We should follow this in spirit. And on corruption, we have not done too well. And this law can actually make citizens the monitors of the government and answerable to them. Next slide, please. What is information? Section 2F defines information. Information means any material in any form, including records, documents, memos, emails, etc., etc., and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. In simple terms, what exists is information, what does not exist is not information. For example, if you ask under RTI, what is the meaning of right to information? If there is a paper or document saying this, it should be provided to you. If there is no such thing, the PI is not expected to generate an answer to meet your question. In simple terms, if I may put it, this is right to information, not right to interrogation. To say, ये ऐसा क्यों किया? अगर रिकॉर्ड पे कुछ है कि ऐसा क्यों किया तो देना है आपको. अगर रिकॉर्ड पे कुछ नहीं है, why is the road bad? If there is something that mentions the on record, it should be given to you. If there is nothing on record, the clear answer would be there is nothing on record. So when you frame RTI queries, please remember, it is not interrogation. It is information. Information is what exists. A building exists, a road exists, all this is information. A file exists, records exist. Next slide, please. Who has to give information? The law defines the term public authority. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature. And A, B, and C effectively cover everything that we call government normally. Panchayat, municipal corporation, municipality, state government, central government, all these bodies are covered by this. There are some bodies that are created by an act of parliament or state legislature. For example, the Sikh Gurudwara Prabandhak Committee has been created by an act of parliament. So that's also a public authority and falls under the ambit of the right to information. By notification issued or order made by the appropriate government. If a body has been created by a notification issued by government specifically, for example, all deemed universities are created by a notification issued by the government. Therefore, they are public authorities and are liable to answer in right to information. And includes any body owned, controlled, or substantially financed. Non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government. It shows that it includes bodies owned by government controlled by government or substantially financed. If enough money is being spent by government, whose money is it? It is my money, your money, it is everybody's money. Some people have this notion, term commonly used is taxpayers' money, by which they mean income taxpayers' money. The money belongs to everybody, and everybody is a taxpayer. The poorest man pays a GST on oil that he buys or various other things that he buys. Taxes are recovered from him also. Besides that, all the assets of the government of India, all the assets of state governments belong to him, which is worth some mad amount. This concept that only income tax payers are useful people is flawed. The ordinary citizen owns government. Everyone, every citizen of India owns the country and has a right over all the information held by the by the government for on behalf of him. And the default mode in right to information is all information belongs to the citizen. Now, there's some controversy about the PM Cares Fund, which is unfortunate. The government says PM Cares Fund is not a public authority under the law because it is not financed by government, nor is it owned, and they say it's not controlled also. Let's examine this carefully. The PM Cares Fund has 4 trustees who are ex officio members of the government. The Prime Minister is the chairman of the trust, and 3 other ministers are ex officio trustees of the trust. On whose behalf are they working? Are they working in their private capacity? The answer is no. Mr. X, Mr. Y, Mr. Z are not trustees. They are trustees by virtue of being ex officio ministers in the government, and therefore they are there. And they are supposed to represent the government's viewpoint. And therefore it is controlled by government. Whenever government officials are ex officio managing some function, they are doing this on behalf of the government and control the system on behalf of the government. Next slide, please. What is right to information? Right to information means the right to information accessible under this act, which is held by or under the control of any public authority, and includes the right to inspection of work, documents, records. You can inspect work, you can inspect documents, you can inspect records. You can go to a government office and inspect a file. You can inspect a road. If a building is being built or a hospital is running, you can go and say, I want to inspect a hospital it's working, and do an inspection. Taking notes, extracts, or certified copies of documents or records. This is what most of the RTI is used for, taking copies of records or extracts from records. Taking certified samples of material. You can also take samples of material. For example, if a road work is going on and you believe the bitumen mix being used is of substandard quality, you can take samples, get it tested somewhere. If you believe the government hospital has got substandard medicines, you can take samples from there and get them tested. This could be a very useful way of checking a lot of things. You are the monitors of this nation. Obtaining information in the form of diskettes, etc., etc. CCTV footage is also included in this and will be a vital source of information because in various places they are putting up CCTV and the footage from these can be obtained to show and prove a wide variety of things. And it's only limited by your imagination of what all can be obtained. Next slide, please. The shortest section in the RTI Act is Section 3, and it's the most powerful and describes it elegantly. Subject to the provisions of this Act, all citizens shall have the right to information. Who has the right to information? All citizens of India. Why? Because the money the government spends, the government belongs to the citizens. The citizens legitimize the MLAs, the corporators, the panchayat members, the central government MPs. All these people get legitimacy from the vote given by the citizen. Now, philosophically, this argument quite often is made. How can anything be denied to the owner? Can any information be denied to the owner is the question. Philosophically, as I said, you can't deny anything to the owner of the. And yet, to run an effective government, certain information would have to be kept undisclosed. And that is what is mentioned in the provisions of this Act, which is Section 8 and 9. There are only two sections which cover the information that may not be given. Section 8 has exactly 10 exemptions, which we'll deal with soon. Section 9 covers copyright. If somebody has copyright over a material or intellectual property right, then that cannot be given, because you cannot go to a government library and say, give me a copy of the entire book because I paid 2 rupees per page. Subject to the provisions of this Act only, no other Act can be used to deny information. Only the provisions of this Act can be used to deny information to citizens. Apart from that, I repeat, default mode is some information belongs to you. Next, please. Section 4 is supposed to be the heart of the RTI Act and represents the true spirit of the RTI Act. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country of different systems that access to such records is facilitated. I want to point out how a very vital part of the RTI Act is being missing. 18 years since the Act came into being, computers are there in all government offices. Every panchayat office has a computer and it has some level of internet connectivity. Most panchayats, at least in Maharashtra, have one person specifically appointed to use the computer and the internet. And what could have happened? The whole concept is all information should be available easily to citizens. You need not even apply. Automatically, all information should be made available to citizens. A very common experience is when a citizen goes to a government office to follow up on an application, complaint, or representation, or to get some information or clarification. Often he is told फाइल नहीं मिलता है, 200 रुपया दिया तो फाइल मिल जाएगा, 500 रुपया दिया तो अकाउंट बंदी हो जाएगा, 1000 रुपया दिया तो फाइल गायब हो जाएगा, and कुछ लाखों रुपए दिए तो मंत्रालय में आग लग जाएगी. This is a common feature. At least 30% of India's corruption takes place by tampering with records. Also, sometimes locating records is difficult. Physically, when you have to locate records, it's a strenuous job. What is the thinking of Section 4? The thinking ideally is, and this is what should happen, all files should be made only on a computer without any paper. Today, the government spends thousands of crores of rupees on paper, an equivalent amount on space to keep these files, and a comparable amount to locate these files. Files नहीं मिलती हैं सरकारी दफ्तरों में. All of this can become history. Unfortunately, that's not happening. All government offices by now should have switched to computerized working with no paper files, except in rare cases. Tampering with a computerized file is far tougher if enough safeguards are put. Some people say government may log nahi hai who can run the office on computers. Let me point out something to you. 20 or 30 years back, the banks went computerized, and bank clerks work only on computers, and most records are only on computers, registers are on computers, lists are on computers, and even a check does not travel from place to place. Only the image travels and gets certified. If the banking industry can work like this, despite direct access to money, and transmit thousands of crores of rupees each day within a state, within a city, internationally, and work properly, there's no reason why it can't. I'm hoping citizens will start demanding that we want computerized working. We want, at the end of each day, all the work done in an office should go onto the web. That would be true democracy. That would be true RTI. Next slide, please. Section 4 expects suo motu disclosures on its own. 17 points in the Section 4.1b, 17 such other information as may be prescribed. The heart of the RTI and satisfactory implementation. Computerization is the key to Section 4 implementation. Proper implementation could improve working efficiency. It would also make the PIO's job easier. Over 50% applications seek information which should be available under Section 4. Incidentally, Rajasthan has launched the Surna portal, in which Rajasthan has been a pioneer in a way in the right to information movement. It started with 3 unique people starting this movement in Rajasthan in early 90s. These 3 unique individuals were Aruna Roy, an IAS officer who quit her job to work for the marginalized and the poor and to make democracy work. Nikhil Day, a young lawyer 20 years younger to her, who was trained in the United States, and Shankar Singh, a man who belonged to rural Rajasthan, who got together with these people and they explained the concept of democracy, concept of RTI, and so on. Next slide, please. Fair enough. I understood what is information, what is right to information, who has to give information. But कहाँ जाऊँ? मैं किसको पूछूं? Should I ask the head of the department? Should I ask the chief minister? Should I ask the prime minister? This act elegantly says every administrative unit of every public authority, I repeat, every administrative unit of every public authority must designate a public information officer whose job it is to provide information to citizens when an RT application comes. Citizen need not know the name of the PIO, need not know his designation. All he needs to do is to address it to the public information officer at an office where he believes the information might exist. Believes. अगर वो सूचना वहां नहीं है, sometimes you may feel that the information should be available in the municipal office, so you apply in the municipal office. Actually, the information may be in the police department, or the PWD department, or some other ministry, or the urban development department. Can he reject your RT application and say, तुम उधर जाओ, हमारे पास ये सूचना नहीं? The answer is no. This law recognizes your sovereignty. बादशाही बेगम को ऐसे थोड़ी हटा देते हैं. The law puts the responsibility on the public information officer to transfer the RT application to the right PIO and intimate to you that he's transferred it to so-and-so who is responsible for giving the information. For this, they get up to 5 days. Within 5 days, they must transfer the RTA application. If the information is available with different officers in the same department, the PIO is expected to ask for the information from the officer and provide it to the applicant. The PIO is a central point and has a very useful role to play in making democracy work in India. Next slide, please. A person who desires to obtain any information under this act shall make a request in writing or through electronic means in English or Hindi or in the official language of the area in which the application is being made. The application can be made in English, Hindi, or the official language of the state. The response will also be in any one of these 3. You cannot insist that because I applied Hindi, I want a response in Hindi. The response will be in the language used by the office routinely. An applicant making request for information shall not be required to give any reason or requesting the information or any other public personal details except those that may be necessary for contacting him. I'm seeing some questions in the chat box. We'll deal with these when I finish. And while listening to this presentation, do not accept everything that I say. Look at it critically. Think in your mind that जो मैं कह रहा हूं वो सही नहीं है. And let's discuss this at the end of this presentation. Now, this is a contested thing that some government officers feel is not right. कि बिना reason के हमको क्यों पूछना? Fundamental rights do not have to show any reason for being exercised. I'm speaking just now. I don't need anybody's permission, nor do I need to justify to anyone why I'm speaking today. The right to express myself, the right to publish what I believe, and the right to information all fall under Section 49, 1A of the Indian Constitution. I do not need to justify or give reasons why I want to publish something, why I want to write something, why I want to sing a song, why I want to deliver this lecture. Similarly, I do not need to give any reasons for accessing information which belongs to me. ये मेरी है information. There is nothing like government. Some people say government को तकलीफ होगा. Government is me. Government gets legitimacy because I vote for them. Otherwise, there is no legitimacy. Next slide, please. On receipt of a request under Section 6, PIO shall as expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed, or reject the request for any of the reasons specified in Sections 8 and 9. Within 30 days, information should be provided to you, or in case some information is exempt, and these exemptions are only there in Sections 8 and 9. No other section can be used. Nobody can say this is confidential and I will not give it. Nobody can say इसका decision ले लिया इसलिए मैं नहीं दूंगा. These are not categories of exemptions. It has to be justified under Section 8 or Section 9, saying Section 9 will come in, as I said, when copyright exists, which will be violated by giving you the information. If PIO fails to give any decisions on the request for information in the period specified in subsection 1, which is 30 days, PIO shall be deemed to have refused the request. And this means refuse the request without any reasons. And this invites the penal provisions of the Act, which we'll deal with later. Next slide, please. Now, is there a fee structure? Do I need to get a form? You don't need to get any form. Any plain piece of paper is your form. Some states, the central government, states, and the courts are accepted as having the right to make their own rules for providing information, detailing. So they can specify fees. In most places, the fee is 10 rupees per application. And for providing the information, 2 rupees per A4 size page photocopy. If it is plans, then the actual cost incurred of getting the copy of such a plan. So the system is supposed to work like this. RTI application comes, PIO sees where the information is available, of how many pages will the information be. Supposing he comes to the conclusion it will be 150 pages, he must intimate to the applicant that this information is 150 pages. Please pay at the rate of rupees 2 per page. So 300 rupees you pay. You pay 300 rupees and the PIO should give you 150 copies of information. Person making request for the information shall be provided the information free of charge where a public authority fails to comply with the time limit specified in subsection 1 is 30 days. If in 30 days information is not provided to you for whatever reason, the information has to be given free of cost. The information is 1,000 pages, the PIO cannot charge you 2,000 rupees. He is expected to give you the information free of cost. Next slide, please. The 30-day period I thought I'll just explain. PIO receives RT application is day 1. After X days, PIO sends letter asking additional fees, 30-day clock stops. Additional fees paid, 30-day clock starts. Information sent after Y days. X plus Y less than or equal 30 days. If RT application is transferred, they get 35 days because 5 days for a transfer. Next slide, please. What should an RTA application look for? You don't need to give any reasons. Yes, granted. But make it an easy experience for the public information officer also. Quite often, citizens voice their frustration in an RTA application. उनको राशन नहीं मिलता है तो PIO पे they take out and taunt him. Don't do that. RTI is an instrument to get information from the government. Recognize that the person sitting on the opposite side is 99% not responsible for your problems. Treat him with respect as you want to be treated by respect. You are the Badshah or Begum of this nation. The PIO is also a Badshah or Begum of this nation. Think of what is the objective or what is it that you feel something is going wrong, some corruption is taking place which you want to expose, or you want to correct some system. Keep it brief. A good rule that I normally use, some states have specified this also, the information seeking should not exceed 150 words. And I have seen that most effective RT applications can be framed in less than 150 words as far as the information seeking is concerned. I'm giving some samples. I'm requesting the organizers to just share the PPT with you. Take a look and learn from it. Next slide, please. Change the slide. Next slide, please. If you want to inspect files, I'm giving a format which might be useful. I want to inspect files relating to so and so. I will bring Mr. So and so to assist me in the inspection. Please suggest 2 dates and the time at which I could come for the inspection. I will identify the documents for which I want photocopies at the time of inspection. Please ensure that the pages of the files are numbered. It is important if you go for an inspection to get the pages numbered. In fact, a government file must number the pages so that no record can be taken out or taken and pushed in. Next slide, please. Likely outcomes of RT application. PIO sends letter asking for further fees to be paid and information obtained by applicant. Satisfactory outcome. You get letter from PIO transferring your application. Further communications will be with the PIO to whom RT is transferred, not the original PIO. You get letter from PIO refusing to give information, quoting an exemption. You feel exemption is justified, accept the decision. You feel refusal is not justified, file a first appeal within 30 days. You must state reasons why you think refusal is not justified. PIO asks you to come for an inspection. If you ask for specific information, he cannot ask you to come for inspection. But if it is difficult for a PIO to figure out what information you may be seeking, he can request you to come for an inspection and select the documents you want. PIO does not respond at all. This is reasonably common situation. This is a deemed refusal without any reason. File a first appeal after 35 days and before 60 days of the RT application. Now, there is a mechanism of a first appellate authority. First appellate authority is an officer senior in rank to the PIO. How do I know who the first appellate authority is? The law requires the PIO, whenever he responds to the RT application, to give details of the first appellate authority, the name, the designation, and the address. But if he has not replied at all, how do I find out? A simple technique is to file a first appeal to the first appellate authority, care of public information officer, at the same address where you had sent the first one, RT application. In the appeal, at the bottom right, that the law expects the first PIO to give me the details of the first appellate authority. Since he has not done this, it is his responsibility now to send it to the first appellate authority. This technique usually works. Next slide, please. Now, here again, I'd once again like to stress, RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. A catena of Supreme Court judgments have held that this includes right to information and right to publish. And therefore, in my opinion, disclosure of information should be subject to almost similar discipline as denial of right to speak, denial of right to publish. If you say you should give public reasons of public interest for giving information, you will then have to apply that to say that my right to publish will be subject to larger public interest only. I cannot publish unless I can establish a larger public interest. When I speak, nobody says, please justify larger public interest. I speak because it is my fundamental right. This is the basis of human rights. These are basic human rights. Now, can this be restrained? Can any information be refused to me as per the Constitution of India? If a right is given to me by the Constitution of India, any restraint on that will have to be provided for in the Constitution, otherwise it will be unconstitutional. Article 19.2 provides the restrictions. The only permissible restrictions are given in Article 19.2, which permits reasonable restrictions in the interests of the sovereignty and integrity of India, the security of the state, friendly relations, foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. Therefore, only on these grounds can any information be denied. Only on these grounds can my right to freedom of expression be denied. Beyond this, you cannot go. And I'll draw your attention to this towards the end of the exemptions. There are only two words that relate to privacy. A lot of information is often denied, saying this is individual's privacy. It is unconstitutional and not as per the law. There are only two words that will apply to privacy: decency or morality. So if something violates decency or morality, it is in the realm of privacy and should not be given, should not be disclosed. We'll deal with this a little more in detail down the line. Next slide, please. Exemption from disclosure of information, Section 8. This is about 380 words, Section 8.1. You understand what the exemptions can be? You should be able to use RTI beautifully well with complete mastery. It's a very simple law. Any average citizen can use it. I'm not a lawyer, I'm just a mere engineer. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen. 8.1a to J lists 10 exemptions. Information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relations with foreign states, or lead to incitement of an offense. For example, supposing the Indian Army, incidentally, is a public authority as defined in the law. Therefore, it has to give information. If you ask, I want details of the troops with the China border, this would not be given to you and it would be exempt under Section 8.1a. This kind of information would be exempted. 8.1b. Information which has been expressly forbidden to you published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Many courts and other bodies refuse to give information, claiming that the matter is sub judice. Sub judice cannot be a matter for refusal to give information. Parliament knows the word sub judice, but they did not use the word sub judice. Parliament said expressly forbidden to be published by any court of law. If somebody is claiming exemption under 8.1b, the judgment or order of a court or tribunal must say this information shall not be provided. Without an express order of this nature, information cannot be refused under 8.1b. 8.1c. Information the disclosure of which would cause a breach of privilege of Parliament or state legislature. What kind of information would this be? For example, commissions of inquiry reports are given to the government by various commissions of inquiry that are set up. If they are not very comfortable for the government, quite often they do nothing with it, they put it in the cupboard and forget all about it. And if a citizen asks, they say it will be breach of privilege because we are supposed to put it on the floor of the house. The law requires these reports to be placed within 6 months on the floor of the legislature or parliament. If it is not put up within 6 months, then they cannot claim this. They would have to give the information because they've already breached the privilege of parliament or state legislature. Next slide, please. 8.1d. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party. This is a larger public interest override, which we'll deal with later. Two conditions have to be satisfied. It should be in the nature of commercial confidence and it should help somebody's competitive position. If one of these conditions is not satisfied, this exemption cannot apply. This requires both these conditions being satisfied. For example, if a tender is awarded, after the tender is awarded, this clause will not apply because nobody's competitive position will be hurt. But before the tender is awarded and negotiations are happening, if you ask for information, they can legitimately claim exemption under 8(1)(b). Information available to a person is fiduciary relationship. Now, what is a fiduciary relationship? People say element of trust is there. I would submit to you let's look at the traditional fiduciary relationships: lawyer, customer, lawyer, client, doctor, patient, banker, customer. All these are traditional fiduciary relationships. The characteristics of fiduciary relationship are as follows. A, they are not statutory relationship. There is no statutory requirement. B, I have a choice of whom to give it to. I give it to somebody with superior knowledge for my benefit. A person gives information to a fiduciary for his or her benefit. He has a choice who to give it to. I can decide which doctor to go to, which lawyer to go to, which banker to go to. There is no law by which I have to go. But if I want to apply for a passport, there is a law which says I have to apply to a passport office. That's not a fiduciary relationship. If I apply for a job somewhere, that's not a fiduciary relationship. A fiduciary relationship is very well defined, where I have a choice of who to go to. There's no law forcing me to go to somebody. And this incidentally has been well established in the Jayantilal Mistry judgment of the Supreme Court, which upheld 10 of my decisions with respect to RBI. Information received in confidence from foreign government. This is the only place where the word confidence or confidentiality has been used. If PIO says information has been received from a foreign government and it's received in confidence, there's no further argument. You have to accept that. The Rafale deal information was not provided based on this exemption. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence of law enforcement or security purposes. Obviously, if something disclosure would lead to somebody's life being endangered, it cannot be given. But there should be a reasonable possibility. It cannot be aisa ho jayega. There must be some possibility that yes, releasing this is likely to lead to somebody's life or physical safety being endangered. Next slide, please. Information which would impede the process of investigation or apprehension or prosecution of offenders. Very often, somebody has filed a complaint and believes that no investigation is happening. So he asks for the progress of the investigation. And PIOs often say 8(1)(h investigation chal raha hai. The law did not say investigation chal raha hai, the information nahi dena. Ongoing investigation is no reason for denying information. Parliament used the word impede. So it has to be shown how releasing the information is likely to impede the process of investigation. 70% or 80% of the times, a person who has filed a complaint is asking for information. And it's laughable to say that he is going to impede the process of investigation. Unless it can be shown that there is a possibility of impediment in the investigation, information has to be provided. Cabinet papers, including records of deliberations of the Council of Ministers, Secretaries, and other officers, provided the decisions of the Council of Ministers, the reasons thereof, and the material on the basis of which the decisions are taken, shall be made public after the decision has been taken and the matter is complete or over. This is a unique exemption. This exemption says up to a certain point in time, information is exempt until a decision is taken. Once a decision is taken, the law says the decisions of Council of Ministers, the reasons thereof, and the material on the basis of which the decisions are taken shall be made public. Suo motu, the government must declare. For example, if a bill is presented to Parliament, there is a process internally. Secretaries will be consulted, others will give their reports, experts will give their reports. The cabinet will take a decision. Until then, the information is exempt. If they present the bill to the Parliament or the state legislature, then it is the property of the Parliament or the state legislature the decision has already been taken by the government, and therefore information must be provided to the citizen. This is the way democracy should work. If bills are to be presented, laws have to be made, citizens must get involved in the consultative process. Citizens must have a right to criticize, to give their opinions. That is democracy. Democracy is not merely parliament passing bills. Next slide, please. 81J is the most misused exemption of all, and I would like you to understand the concept of this. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. Public interest override we'll deal with later, provided that the information which cannot be denied to the parliament or state legislature shall not be denied to any person. What does this say? Very often, rejections are made by PIOs, first appellate authorities, commissioners, and courts, saying this is personal information, hence information cannot be given. Wrong. This is illegal, contrary to the constitution, contrary to the law. 81J says if it is personal information, it may fall under exemption of 81J. It has to be seen whether it has any relationship to any public activity or interest. 99% of the information in government records is a consequence of a public activity. What I eat at home is not on records of government. One retired Supreme Court judge asked me, Mr. Gandhi, do you mean to say you will ask what I ate in the afternoon at my lunch? I said, sir, what you ate in your house at lunch is not part of public records. But if the bill has been paid by government, then it is part of public records and I have a right to ask what was served at lunch. So therefore, 99% of the information is a consequence of public activity, or which would cause unwarranted invasion of the privacy of the individual. Now, this is a conundrum that's peculiar now. What is privacy? How do we define privacy? The Puttaswamy judgment has said privacy is the fundamental right of citizens. Yes. Read the entire Puttaswamy judgment of 550 pages plus. And if you are a PIO, you do not get to know specifically what to call privacy and what not to call privacy. There are lots of theories propounded in the 550 pages plus judgment. But a poor PIO, वो judge कैसे करेगा? The Puttaswamy judgment very helpfully says what constitutes privacy will develop on a case-to-case basis. So imagine the RTI Act, every time there's some personal information, ये privacy है या नहीं, the PIO must go to the Supreme Court and say, sir, ये privacy में आता है कि नहीं आता है? That would be absurd. I wish the Supreme Court had defined certain clear areas. In earlier judgments, before 2005, the realm of privacy has been defined in Supreme Court judgments. In the Kharak Singh case, in the R.R. Gopal case, in Govind's case, and so on. Unfortunately, the Puttaswamy judgment does not. But to make a practical thing out of this, if I look at Article 19.2, there are only two words that apply to privacy: decency or morality. If disclosing some information violates decency or morality, it should not be shared. And Parliament realized this conundrum, and therefore they added an elegant line, an elegant proviso to 81J, provided that the information which cannot be denied to the Parliament or state legislature shall not be denied to any person. What does this mean? It has to be given some meaning to. In my opinion, whoever claims exemption under 81J and says I'm denying information must make a statement that, in my opinion, in my subjective assessment, I would not give this information to Parliament or state legislature, and this is constituting violation of privacy. Without this, there are Supreme Court judgments which have allowed Section 81J without mentioning this. And I believe they are not as per the law, not as per the Constitution, not as per the RTI Act. Notwithstanding anything in the Official Secrets Act, nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to protected interest. What this clearly means is if an exemption is claimed and an exemption applies, if you are able to show a larger public interest in disclosure, then a balancing act has to be done. And if it is felt that there is a larger public interest in disclosure, information should be given. These are rare cases. Information commissioners or courts have very rarely said that this is exempt under section 81A, B, C, D, whatever, but there is a larger public interest in disclosure. These are extremely rare cases and are very difficult to establish. The clause is good. The provision is a good provision, but it can be used extremely rarely. Subject to the provisions of clauses A, C, and I of subsection 1, any information relating to any occurrence, event, or matter which has taken place, occurred, or happened 20 years before the date on which any request is made under section 6 shall be provided to any person making a request under that action. Two kinds of gross, funny misinterpretations are made. One is PIO say ये information देने का ही नहीं है. Applicants at times say that information has to be kept beyond 20 years. What this section means is, after 20 years period is over, only 3 exemptions will apply. This is like Amitabh Bachchan's 50-50. Here it is 70-30. 7 exemptions do not apply after a period of 20 years. Therefore, 81J will not apply after 20 years. After 20 years, only A, C, and I section will apply. 7 exemptions do not apply and cannot be claimed as exemptions for disclosure. Next slide, please. Unfortunately, the Digital Personal Data Protection Act, Section 44(3), has talked of amending Section 81J of the RTI Act in this manner. Amends RTI Act 81J thus and exempts information which relates to personal information. All the rest they decided to omit. I do not know how this will play out, but this could actually become a very deadly thing which can finish the Right to Information Act over a period of time, and it will become a right to deny information, because most information can be linked to some person. Information relating to a person, if it's personal information, and if it can be denied, I suspect it will mean the PIO will have complete freedom to deny most information and nobody will be able to question it. This will become a right to deny information. I believe citizens must protest about this and say that this should not be done. DPDP Act must not override RTI Act Section 38(2), and no amendment to RTI Act, signed petition, and so and so. Next slide, please. One or two slides have been added just to clarify 81J position. Next slide. Next slide. Next slide. Do look at these slides because they give some explanation as to why 81J is a limited exemption and not as widespread as is being sought to be made out. Next slide, please. Okay. Section 19 talks of first appeal to first appellate authority within 30 days for not getting information, incomplete information, or wrong information. First appellate authority should decide in 30/45 days. The period given for him is 30 days, but 15 days more can be taken by giving the reasons. If result of first appeal not satisfactory, the second appeal to the commission within 90 days. Section 19(5), onus on PIO that denial of information was justified. You do not have to justify why you want information. Strictly as per the law, the PIO has to justify denial of information. The applicant has to say nothing. Because it's your right. If आपकी ownership का information आपको नहीं दिया जा रहा है, he has to justify कि ऐसा काम क्यों हो रहा है. Next slide, please. Carefully look at the response and see if information has been provided. Information can only be denied if it is not available, if it is exempt under section 8 or 9, or file not found. If somebody says, I can't find the file, very common experience is file मिलता नहीं है, file misplaced. Insist that this means the file is lost or stolen, and therefore a FIR must be filed with the police for loss of government property. Quite often the PIO will say, नहीं नहीं चोरी नहीं हो गया. आज के आप कैसे बोल सकते हो? अगर फाइल नहीं मिल रही है आपको, चोरी नहीं हो गया, ये आप किस हिसाब से बोल सकते हो? अगर आपको पता है फाइल है तो ढूंढो उसको. नेक्स्ट स्लाइड प्लीज. Section 20 is the teeth of the Act. This is the reason why the Act works to whatever extent it does. If information denied without reasonable cause, Commission must delay. The PIO deemed PIO at rupees 250 per day of delay after giving an opportunity of explaining. Maximum penalty rupees 25,000. Commission can also recommend disciplinary action against the officer and compensation to be paid to applicant. The Commission has been given fairly wide powers. Sometimes people say commissions don't have enough powers. I submit adequate powers have been given. When I worked as a commissioner, I did not find loss of any strictness in imposing the orders and getting the orders implemented. Enough powers are given to the commission. They have to be used and exercised. And it must be done in a time-bound manner. In our country, the whole concept of justice in quasi-judicial proceedings has been made completely worthless by timelessness. All decisions, judicial, quasi-judicial, or at least most of them, there will be some rare exceptions. They should be the exceptions. Most decisions should be taken in a time-bound manner. If they are taken in a time-bound manner and in a fair manner, the rule of law will prevail. Many of you might know that we rank 77 or 79 in the rule of law index worldwide. We say we want to be a first-rate nation. With a third-rate rule of law index, we cannot be a first-rate nation. Please understand, timeliness is most important. RTI, the law specifies this, but a lot of commissions and judges and PIOs and First Appellate Authorities do not respect the timeliness required. Next slide, please. The provisions of this Act shall have effect, notwithstanding anything consistent therewith contained in the Official Secrets Act and any other law of the time being in force or in any instrument having effect by virtue of any law other than this Act. Quite often, when dealing with the law, people say the Banking Act says this, somebody says the RBI Act says this. The general category, general interpretation says this. The RTI law says, as far as the RTI is concerned, it overrides all existing laws, and therefore those excuses cannot be brought in to deny information. Next slide, please. Just trying to put this in a short way. RTI application information should be obtained in 30 days. If no response provided or unsatisfactory response, first appeal to be filed in 30 days of response or 60 days in case of no response. First appellate authority order after hearing within 45 days. If unsatisfactory order or no response, second appeal to commission within 90 days of first appellate authority's order or 120 days from date of first appeal if no order received after first appellate authority. This, in short, is the RTI Act operation. Extremely simple to use. Do use it. Next slide, please. This is a format for Maharashtra, can be used for central government bodies also. And this is a very famous story of RTI usage. One young boy had come from Bihar to Mumbai to get a job. Where did he stay? He stayed in Jhopadpatti with a chacha of his. While he was going around trying to get contacts, relatives, friends, so that he could land a job somewhere, he heard that there was an RTI workshop going on in the Basti. RTI workshops are held in various places, including Bastis, hutments, housing societies, colleges, schools, law colleges, and variety of places. He heard he had nothing to do, so he sat down and said, "चलो सीख लेते हैं, सत्यनारायण की कथा जैसे सीख लेते हैं, इसको भी कुछ समझ लेंगे हम." He understood what is information, what is right to information. Information has to be sought from the public information officer. 10 rupee application fee has to be paid. Information can seek what is on record. It is not right to interrogation. And any plain piece of paper can be used. Having understood all this, he moved on. After a few days, he got a job. And this I'm talking of 2006. After that, he needed what at that time there was no Aadhaar card, proof of identity for people staying in huts, in particular, a ration card. So he went to a rationing office, submitted his ration card application there. As he was going out of the door, the peon accosted him and said, "आपको ration card चाहिए क्या?" He said, "हाँ भाई, इसीलिए तो फॉर्म भरे." Peon said, "चाय पानी लगेगा." This boy said, "ठीक है, आपको चाय पिला दूंगा." The peon said, "चाय पिलाने की बात नहीं है." He said, "तो फिर क्या मतलब है?" He said, 2,000 रुपये देना पड़ेगा, तभी राशन कार्ड मिलेगा. This boy, without batting an eyelid, said, "मैं घूस नहीं दूंगा. I shall not give a bribe." The peon shrugged and said, "ठीक है, तुम बिहार से आते हो, अकल तो है नहीं, बम्बई शहर कैसे चलता है, तुम जाओ, तुमको राशन कार्ड इस जगह में नहीं मिलेगा." This boy went back. He found out from others in the basti that everybody was getting their ration cards in about 40-45 days by paying about 2,000 rupees as bribe. He waited about 3 months and he gave this RT application. Description of information. I had given an application for a ration card on 5th August 2006. Photocopy of receipt attached. I want the following information about his progress in the following format. Next slide, please. Date on which application received, name and designation of the officer receiving it, action taken, date on which forwarded to next office. Photocopies of all letters and notice to be provided. 2. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were issued. इसका जवाब क्या देते? He did not say मेरा ration card क्यों नहीं मिला. He asked for something that has to be on record. What answer would they give him? Your application has not been moved at all to Japan in India, and others who have applied after you have got their ration cards. There was no reason they could give on paper. So next day the peon came to his house and said, "Saab ne bulaya aapko." He went to the rationing office. As soon as the officer saw him, the officer told the peon, "अरे अरे ये साहब आए, इनके लिए कुर्सी लेके आओ और इनका राशन कार्ड लेके आओ और एक कप चाय और एक गिलास पानी लेके आओ." He did not give chai pani, but he got chai pani instead. And that, to me, that cup of tea is respect for the individual sovereign citizen of this nation. It goes far beyond just a cup of tea. It goes far beyond bribes and corruption. Respect for the individual citizen is what is true democracy. Respect for the individual citizen is what right to information is all about. Transfer of power from the powerless, from those with power to the powerless. Creating a society which lives by the rule of law. Those are the objectives of the right to information which can be achieved. The best monitors of government are the citizens of India. Incidentally, you might well know most or a lot of Western countries do not have vigilance departments in every government department. In India, we have vigilance departments in almost every government department. उससे कुछ होता नहीं है. So we created an anti-corruption bureau. Anti-corruption bureau भी कुछ नहीं कर पाता है. Therefore, we created a Central Bureau of Investigation, CBI. उससे भी कुछ नहीं होता है. तो CBC बना दिया, Central Vigilance Commissioner. No difference. We created a Lokpal. Lakhs of citizens came out of the streets of India. लोकपाल आ गया, 3-4 साल हो गए. दिल्ली में बैठा 20 से 30 करोड़ रुपए महीने का खर्चा करता है. क्या करता है? इल्ले. Citizens of India are the best monitors, best vigilance monitors for the country. They own the nation and they will serve the country well. We can get into a different phase altogether. The power will get transferred from those with power to those who are powerless. We will have a society that is just and fair. That is possible with RTI. Next slide, please. Now, this was my own RTI application. This I'm showing you to illustrate how much power you can get out of RTI. This was before I became a commissioner. I was an ordinary citizen of Mumbai. doing my business, doing my work, and had nothing to do with anything. One fine day, I found on the first page of Times of India a big photograph of citizens demonstrating in a public place in Mumbai because one police constable More had raped a minor. They were demonstrating saying action should be taken. On the same day, on page 5, I saw a small news item. The small news item said that one police inspector, Prakash Avre of Mumbai Police, had raped a minor the earlier year. He was suspended from service. Case was filed against him. In the case, they did not present enough evidence. Therefore, the court released him and dismissed the case. And Police Inspector Prakash Avre was being reinstated in service. One day, on one hand, citizens demonstrating because one police constable More had raped a minor. On the other hand, a joke was being made out of this. मुझे गुस्सा आया, so I decided to use RTI. I repeat, nobody knew me in Mumbai. Description of the information required. Next slide, please. According to a news report in the Times of India dated 29th April 06, Inspector Prakash Avre was accused of raping a minor girl in September 2005. He was acquitted by the Sessions Court in February and has been reinstated in service. I want a photocopy of the order reinstating him, along with the 5 notings based on which the decision was taken. I did not say, आप क्यों उसको करते हो, ये गलत है. No, I passed no comments. I only asked for a copy of the order reinstating him and with the reasons on record. Next slide, please. This was not given to me, and I filed the first appeal. I want to show you the first appeal also. Next slide, please. Appeal. Grounds for appeal. Facts of the case. I had asked for information regarding the reinstatement of Inspector Prakash Avre as per the attached application. Next slide, please. The PIO first sent me a letter stating that the information will be provided by Bhaikala Police Station. PIO Bhaikala replied by his letter of 16/5 that the information could not be provided as it was exempt under Section 81H, which exempts information which would impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. PI has not shown how providing the information would impede any investigation. In fact, no investigation is being held since Prakash Avre has been reinstated. The reaction is without any basis in law. They called me for a first hearing. There was a deputy commissioner of police who was a very good officer. The reason I'm saying this, there are good government officers, but they are ineffective because the citizens are lax. We need to become active citizens. So this DCP said, Mr. Gandhi, what could we do? The court has released him. I said, sir, from my viewpoint, there are 2 possibilities. A, Police Inspector Prakash Avre was innocent, in which case someone framed him. Such a person's action should be taken against. Alternately, Prakash Avre has actually committed the crime. He's stated to have committed, in which case reinstating him is a big disservice to the citizens of Mumbai and to the police force itself. The DCP saw the point I was making and he said, let me see what I can do. In 20 days, I got it in writing from the police commissioner's office that Police Inspector Prakash Avre had been dismissed from service. That is the power of right to information which an individual citizen can exercise. Yes, it was a very good police officer on the other side who was looking at his duty seriously. ऐसे भी लोग हैं. हमें कुछ करना पड़ेगा. If we don't do anything and keep cribbing, nothing will change. A survey of mine shows that almost all Indian citizens crib for about 2 hours every month about what is wrong with India. Minister ऐसा है, politician ऐसा है, judges ऐसे हैं, रास्ते ऐसे हैं, फलाना ये है, यहाँ corruption है. Does that cribbing change anything? Can it change anything? The answer is no. Then why do we do it? Maybe it's good for our mental and physical health. My submission is, if it's good for your mental and physical health, continue doing it for 1 hour. 1 hour out of that, think of doing something that is likely to have an impact on the nation. Likely to. It doesn't necessarily, everything will not get converted. According to my analysis, when the RTI Act came for the first 5 or 6 years, about 25 to 30% of the RTI applications had some impact, some small impact on the governance. Now, the courts and the commissions, etc., are poorer in implementation and are interpreting the law very badly. Consequently, now it's about 15 to 18%, some impact on the government. Here's a dream I want to share with you. If 60 lakh Indian citizens take a vow once a month to file one RTI application on a subject that concerns them, on something that they feel upset about, even if they don't follow up, information आया नहीं आया क्या हुआ परवाह मत करिए. If 15% times the government gets some change, some changes made in the government, 1 crore times some change will happen in the government. If 1 crore times we are able to impact the government each year, in 5 years, we'll have a much better governance, consequence of RTI, consequence of active citizenship. You need not even come together. You need not form a political party. सिर्फ ये कहिए कि मैं 1 घंटा महीने में निकालूंगा देश के लिए कुछ करने के लिए. And I'll do it from my own house, from my own. I need not go on demonstrations. I need not do all those things. I can make a change, and you can make a change. At one talk again, when I was talking like this, there was a gentleman my age. मेरे जैसे बुढ़े थोड़े cynical होते हैं. He said, sir, मैंने 10 साल तक बहुत कंप्लेन किया, बहुत RTI किया, बहुत कुछ किया. कुछ नहीं होता है. इंडिया में कुछ होने का ही नहीं है. इंडिया में कुछ हो ही नहीं सकता है. अपना सब भ्रष्ट है, सब सिस्टम खराब है. To such friends I say, many of us go to mandirs, masjids, gurudwaras, agyaris, derasas, whatever. Once a day, once a week, once a month, maybe once a year. When we go there and come out, do we have an extra 100 rupee note in our wallet? No. Do we feel we become younger, more handsome, more beautiful? Kuch nahi hota hai. There's nothing you can notice. Then why do we do it? We do it as an act of faith. We have faith that by doing this, something good will happen to me, my family, my friends, my society. What do we do for the nation as an act of faith? Let us try this as an act of faith for the nation. We can bring change in this nation. Individually, and this is important, this is extremely important. Individual citizens should be able to bring change. You don't need to have political parties, you don't need to have gunda parties, you don't need to have big strengths. The individual citizen is where the heart of democracy lies. Empowering the individual citizen, and RTI empowers the individual citizen. If RTI is being wrongly implemented, we need to create public opinion about it. Try the extremely simple act. I'm repeating, I'm requesting the organizers to distribute the presentation and the RTI primer to all of you. And I'm hoping each one of you starts believing कि आप बादशाह या बेगम है इस देश के. I've had the privilege of addressing the Badshahs and Begums of India. Thank you very much. Next slide, please. Some RTI applications will be filed online. You can take a look at the internet and figure that out. Next slide. मेरा भारत महान हम कहते हैं, टेम्पो ट्रक्स के पीछे लिखते हैं, but we don't really believe it, do we? Therefore, next slide. मेरा भारत महान नहीं है. I say मेरा भारत महान नहीं है. Last slide, please. मेरा भारत महान नहीं है, पर ये दोष मेरा है. I, the individual sovereign citizen of this nation, am responsible. The Badshahs and Begums of this nation are responsible. You cannot get away by saying ये ठीक नहीं करता, वो ठीक नहीं करता. अकबर बादशाह या शिवाजी महाराज did not say कि ठीक नहीं चलता है तो और किसी कोई दोष है. They set about correcting it, and we can correct it. There are good government officers. We can back them with RT applications. जो गलत कर रहे हैं उनको हम ठीक कर सकते हैं. Thank you very much. God bless you. Thank you.
Thank you so much for an informative session, sir. Now I would like to take up the question and answer on behalf of the participants. So I request the participants to kindly drop their questions in the chat box, or you may also raise your hand and we'll unmute.
कोई क्वेश्चन नहीं आ रहे हैं?
Uh,
हर चीज
so,
जब ऐसा होता है तो इसकी दो पॉसिबिलिटी होती हैं, या तो इतनी अच्छी तरह समझा दिया सबको कि सब कुछ समझ गए, या कुछ भी नहीं समझ पाए. Okay, I see one question from Dr. Pranay. It says under trials prisoners कैसे यूज कर सकते हैं? A lot of things that they don't get, they can ask through RTI and say कि ये कितना दिया था, किसको दिया था, कौन से टाइम लास्ट दिया था, फलाना साबुन दिया या जो भी दिया. Another very powerful thing, I have used it, but unfortunately I'm not able to pursue it further. There is a, I think 236A या 436A, जो कहता है कि अगर under trial prisoner has spent 50% of the time for which जो भी उसने गुनाह किया है, the alleged crime, उसका मैक्सिमम सेंटेंस जितना है उसका 50% अगर वो जेल में रह चुका है तो, और बेल और नहीं फर्निश कर सकता है, उसको पर्सनल बॉन्ड पे रिलीज करना होगा. ये कानून है मगर ये इंप्लीमेंट नहीं हो रहा है. मैंने आरटीआई के तहत कमीशन से एक ऑर्डर निकलवाया था जिसमें यह कहा था कि महाराष्ट्र में हर प्रिजन में हर महीने के आखिर में लिस्ट ऑफ प्रिजनर्स एंटाइटल्ड टू दिस रिलीफ होना चाहिए और वेबसाइट पे भी होना चाहिए. इसको भी अगर हम परस्यू कर लें तो काफी अंडर ट्रायल्स की तकलीफ कम होगी. और wherever their rights are denied to them, because and many of you may be aware, India is one of the worst countries in terms of under trial percentages. Over 75% people in our prisons are under trials. मतलब 4 लोग पकड़े तो 3 लोग तो अंडर ट्रायल्स है, कॉन्विक्ट्स ही नहीं है, और उन्हें हम सड़ा रहे हैं. We have more people concerned about animals in prison than human beings in prison, which is a sad commentary on us.
Another question is, how do you face the challenges from the authorities or the politicians when you file an RTI which may trouble them?
See, okay, one thing that I have done over the years since I have been in public work is never target individual, target a system. आपके खोपड़ी में भी नहीं होना चाहिए कि मैं इसको ठीक कर लूंगा. ये मैंने देखा है, आरटीआई में थोड़ा सक्सेस मिलता है तो लोगों के दिमाग में भी घमंड आ जाता है, और वो कई बार कहते हैं किसी को, पावरफुल आदमी को, कि मैं तेरे को ठीक कर दूंगा, या गुंडे को या बदमाश को मैं तेरे को ठीक कर दूंगा. ये ना करके, आई हैव नेवर बीन कॉन्शियस ऑफ हु इट माइट affect, not try to find out anything about them. The attempt has been to clear the system. If we, अगर सिस्टम को ठीक किया तो सब अपने आप ठीक हो जाएगा. हर चीज ठीक करना हमारे लिए मुमकिन नहीं है. Avoid that, and my feeling is, at least my example is, मैं कोई बहुत तगड़ा आदमी नहीं हूँ, बट आज तक किसी ने ना थ्रेटन किया है ना कुछ किया है. And I suspect that is because I've never, I've, there are lots of big things I've taken up, but never thought in terms of किसको ये affect करेगा या इसको मैं ठीक कर दूं. ऐसा दिमाग में कभी कुकड़ी में नहीं आया. एंड अगर फिर भी डर लगता है तो get somebody from a different city to file an RT application. Another alternate technique people try is 8-10 लोग साथ में फाइल करते हैं, because generally अगर 8-10 लोग हैं तो थोड़ा मुश्किल है किसी को उनको टच करना.
Thank you so much, sir, for answering the queries. Now I invite Dr. Alpesh Kumar L. Gupta, the founder of ProBono India, to deliver the vote of thanks.
Thank you very much, Harsh, and thank you very much, Shailesh sir, for sparing your valuable time on this Sunday. Let me tell all the participants, I have learned a lot of times in touch with sir more than a decade. I have learned a lot of things from sir when he was a commissioner. Before that also, and after that, I can see like every week or maybe there's so many programs that he has been doing for under RTI and then making all the people on aware about the RTI, how to use RTI, and then. A lot of initiative was also taken, sir, related to the pendency of cases also, sir, keep sharing those information also. So again, this is again, I would say, wherever you are, and rightly, sir, pointed out, spare some time, like, sir, it's like stated, like 1 hour in a month, right? It's a very good message, I would say. Not, at least you can do some activities in a year, right? So, and make a difference. And if we think in the direction, so that again, definitely, and then unfortunately, I have seen in some many law schools this RTA is not being taught. So this is the way we learn. Let me tell you, I also discussed in my session. There was no syllabus, this paper in my LLB, LLM also. I learned from my side, and then keep practicing this thing. I have learned a lot of things from you and other couple of RT activists and Ahmedabad and other places. So sir, on behalf of organizing committee, I am thankful to you sparing valuable time on this Sunday, sir. Look forward to see you in future events also. Thank you very much, sir.
Thanks to all of you, and my respect and my salute to the Badshahs and Begums of India.
Thank you, sir.
Thank you, sir.
Participant, please stay back. Shailesh sir, this was the last session for the course. I think sir is left. Okay, no. So thank you very much, participants, and thank you very much, Hers, for here. I know faculty members are there. There's a CLAT exam, entrance exam is there today, so all are busy, and the participants. So we are open, right, for the feedback. You can raise your hand, unmute, and share your experience. How was what new things can be done? Anything comes to your mind. You can raise your hand. We do not want it. Message in the chat box. Please raise hand, and then we'll unmute you. Yes, please.
Hello.
Yes, Bully. Yes.
Yes, good afternoon, sir. This is extremely informative session that I have listened throughout your all the office sessions are quite informative and interesting. But this session I found really interesting because what I found there was a many things he actually explained very nicely. But one thing that's my feedback. Please don't take it otherwise. But earlier in free session also I raised my question, but I found that it was not reached to the concerned person. Even today, I asked also a question. I sent to Hertz. I sent to the respected sir also, but he didn't leave. Kindly, okay, look into the matter because this is a practice. Because I have filed several RTIs and the government has not simply answered. Government has merely bypassed it, and he has guided me in what he has okay, shared today. From there, I can also get, but there is still some questions left unanswered. That is what I asked the question, but it didn't reach to him. So kindly, from the next session or the next time, whenever we'll meet, I request sincerely, humbly, that kindly look into the matter so that we can be properly addressed.
Mr. Menon, I would just like to say that, at times there are restrictions from our end as we cannot take up all the queries as time restricts us. But however, contact details of all the resource persons are shared with you. So if it is not taken up during the session, you may ask them personally. Mr. Rupesh, over to you next.
That's right. So I just had one query, which I was highlighting in this, it's not, you do need to address the system, not the personal thing. But what happens is we see that when that person is the system over there, then it gets into trouble. So I have filed a few queries on RTI earlier, and I have seen that because of my RTI, I have seen some change of
Want general.
things happening against
Sorry,
me.
sorry for interruption. Participant, we need feedback from general on this course. General feedback, not particular session.
Yeah,
So
so
sorry.
sir, I have been listening to many sessions, so it's very nice. I am a law student by per se also, and been a law teacher also for various technical courses. So for me, this is totally out of the college thing or out of something which I gained from sessions conducted by Pro Bono India. So I think it's delightful for many teachers and also the students of law school. So thank you so much for taking the extra pain and making people aware of various topics which are little difficult to understand or not being taught in law schools. Thank you.
Part of various other editions also. And I really appreciate this particular task that you take to organize this. Sir, right from the first session where our Dr. Patil had spoken about legal aid, then Professor Prasad's session, even the cyber law session, all are distinctive and they are so informative, including today's session, that it is really appreciated that you had a variety of sessions. It was not only concentrated specifically to legal aid, but we were the informative part came from various dimensions. So really, I would say look forward to another fifth edition also, which was different. Like, because every year that I attend your sessions, every time it has been different. It is like from the last session, it was much more informative. It gets better and better. So, and of course, sometimes I do feel that there have been internet issues. Definitely, it is not from the speaker side, but maybe that connectivity problem everyone has. Rather, let rest assured, I feel all other things were really appreciable. So that is what feedback I would suggest, and best of luck for any future endeavors.
Thank you so much, ma'am. Mr. Amit Kumar. Mr. Amit Kumar, I hope I'm audible.
Yeah, yeah. Good afternoon. It's my feedback is myself Amit Kumar, and I am as a professional. I'm not an academician and all, but I find this course is extremely very nice. I'm having almost 19 years of experience, so I have also learned a lot of things. So this is a particular course which I have seen it. It's very professionally managed, covered almost all dimension. It has covered with related to content experience. It has not. I never felt as if I'm in the law classroom and all. It's a very based on practicalities. Your experts are completely from all fields, academicians as well as and they are dealing with the practical aspects. So it's really full of learning kind of thing. I have only one suggestion. If one sessions can be given to the banking law and their disputes, which is also touching to everybody, it will be eye on the cake kind of thing. I give it more than 100%. The effort, coverage, exposure. It's really very nice course. This is what my feedback. Thank you to all, including Kalpesh sir and all team of the National Law University and Pro Bono.
Thank you, sir. Dr. Pranay.
Hello.
Yes, sir, you're audible. Please continue.
Hello. Am I audible, sir?
Yes, sir. Please continue.
Okay. Okay. Myself is Dr. Pranay Kumar Aditya. I am from a very small place at Kokrajhar in Assam. So primarily, I extend my heartfelt gratitude to Pro Bono India founder, Dr. Kalpesh Kumar sir, along with the university as a co-organizer for this program. Now, initially, as I have said, from 16th, we are at around 16 days. So Professor Dr. Ashok R. Patel, Vice Chancellor, in his inaugural session, very convincingly extended his speech, which is beneficial to us. And finally, I have seen that the whole idea has been carried out very smoothly, benefiting all the participants. For that reason, I extend my humble gratitude to Pro Bono India as well as the NLSUI Ranchi University as a co-organizer for organizing this program along with all the team members. And also I extend my thanks to the participants for actively taking part in these whole sessions. Now, as far as the learning points are concerned, I have taken away many of the things, although I have a long experience in teaching law for around 28 years, but it is great after a long time. And I can also say very openly that I've attended and completed many of the refresher courses, an orientation program, FDPs, etc. But compared to that, this program is more and more beneficial for all the participants, the faculty as well as students and anybody who took part actively in this program. So thanks a lot for organizing this program, and hope in future it will be conducted at various other places in physical mode or in virtual mode, whatever it is. And many of the participants would definitely get a chance to become a member of the Pro Bono Society. And finally, I made a request if the organizers can make the certificates available to all the participants, irrespective of anything, that would be great for all. So with this, I conclude. Thank you very much. Namaste.
Thank you so much, sir. Next, Mr.
Whether my voice is audible, Anmol sir?
Yes, yes, you're audible, sir. Please continue.
Sir, I thank Kalpesh Kumar sir and Anmol and the entire team of for conducting a very good program. What I perceive is all the sessions were technically very organized. Experts from academia and advocates were part of this. But one suggestion, what I can give it from my point of view. Now, the course can add a few more people from industry who are advocate as well as the experts who are dealing with various aspects which is connected to legal aid for that matter. We could have added persons from Lok Adalat or judicial bodies like registrars who are handling this, or the officials in public department, how they are facilitating the process of legal aid or amicable settlements of disputes like that. That can also be planned. Kalpesh sir and Anmol sir, you can see, because this is a continuous process which you are doing, and I have attended 1 month refresher course, and this is the second program I am attending from your end, Pro Bono India, and it was very fantastic. And if these things can be added, then yes, it would be other advantage, because academician does not have an direct inputs with the people who are connected in industry, and or those who are very much who are in the
Sir, you are not audible. Believe we should move to the next person now. Mr. Amit Kumar.
So
Mr.
we will
Anand Kumar, if I'm audible.
he has already spoken. Two are lined up. So we will take up two feedback and then we'll close for the day. So we have Swami and Tulya Singh. She is left. Yes. We'll take two, Swami and then followed by Tulya. Over to you.
Sir, I would thankful to the organizer. So it was very beautiful and wonderful session, which is organized by the institution. And one more, which is the topics is very good, and very eminent experts who are deliver the classes. It's more helpful to the students, especially also we have very interested to learn the faculty, and also it is better. My suggestion is that it is better to keep moving, continue. I'm very thankful to. I'm very happy, sir. Thank you. Over to you, sir.
Thank you so much, sir. Ms. Tulya. Ms. Tulya, you may speak now. But it seems she isn't available. You may wind up now.
Okay, so let us, I think we close. So thank you very much all the participants for your kind feedback. And then let me tell you, we didn't expect we'll start this course. No, okay, in Corona time we started, and then we are not expecting this will go for second, third, and fourth edition. So I'm thankful to NLU Ranchi Professor Ashok Patil sir. I was talking with sir when he joined. He told me, sir, Kalpesh, if you're planning something in pro bono, please let us know. So I proposed two, three things, including this course, and he readily agreed with this course and then provided very good support. And let me tell you, this fourth edition went like very like with lot of ease. Like special thanks to like team of Clap NLU Ranchi, and you can see whatever recordings that we are having. The Hers is spending 3 to 4 hours every day and then providing recording. So it never happened earlier. Also, we used to provide recordings after 3 4 days. That again link and then passwords you have to see online on WebEx platform, and then YouTube the way the service is given. That's very accessible. Right? If you're moving here and there and can go through it in the quality of the video and entire things, and with the like a minimum the I would say team members. Earlier we used to have 10 plus, including 3 4 faculty members, 8 10 students. This time, with minimal the team members, we did wonderful job, I would say. So thank you very much. Harsh, you'd like to share something as a student coordinator, right? And then we'll close. Over to you, Harsh.
Thank you so much, sir. And really, the experience has been amazing all this while. It was great to see, participants joining in large numbers every day and actively participating in this course. Now, just a suggestion for the participants. As you all know, we have been uploading the YouTube lectures. So we will be sharing the links to our YouTube channel and all the social media platform for both Pro Bono India and Center for Legal Aid program in our WhatsApp groups. We hope you will visit these platforms for more materials and ready information on legal aid. And you may access the recordings before the final test. Thank you. Thank you, everyone. Thank you, sir.
Thank you very much, Harsh, and all the team members. Thank you, all the participants. Thank you very much.